Good morning, everyone. Welcome to our webinar today. We're just going to give everyone a couple of minutes so they can come into the room, and then we'll get started with today's webinar. So just give us a few minutes to let others come into the room, and we'll get started. I hope everyone's enjoying this sunshine that we're having this morning.
What about that moon last night? Did
Oh
you see the
my
moon?
God.
Wasn't it
Yes, it was
beautiful?
so
Yeah.
beautiful. Yeah, I saw it on my way home. I was coming in from Baton Rouge, and so as soon as I came in the Shreveport, I was like, "Oh my God, look at the moon!"
hmm
So I watched it all the way home.
It looked fake.
It did, and it was low. It was so
It was
low. I was
very low.
surprised.
Yes.
Yeah. So we do have people joining us. So I think we can go ahead and get started, Patricia, because I know you have
Okay.
a lot of great information to cover.
Okay.
Okay, so again, I want to welcome everyone to our webinar this morning. We have estate planning, probate, and special needs planning with Miss Patricia Miramon, and she's an attorney with Miramon Law Incorporated. Patricia has worked with families helping families for years, so we thought that this would be a great opportunity for her to come in and share some important, valuable information with our families. So to introduce myself, my name is Chanel Jackson, and I'm the Executive Director of Families Helping Families Region 7 in Northwest Louisiana. Families Helping Families Region 7 is one of 10 Family Helping Family networks throughout the state, and we focus on information and referral, education and training, and peer-to-peer support to individuals with disabilities and their families. And today's webinar is going to cover an important topic that I feel that all of our families need to know to make sure that they have the appropriate planning for the future for their loved one. So, Patricia, I'm not going to waste any time. I'm going to let you go ahead and get started. Just remember, if you have any questions, please feel free to put them in the chat, and Patricia will answer them along the way. So, Patricia, I'm turning it over to you.
Okay. All right. Well, good morning, everybody, and thank you for logging in. So, the first couple of slides, excuse me, on the presentation just have to do with a little bit about me and about the law firm. And I'm not going to spend a lot of time about that, but basically, I have been working with families helping families. I've been working in this area for 40 years. And the picture that's on the front there is my daughter, who's been working with me since 2019. What we do is we focus in the areas of estate planning, which means, of course, wills, trusts, powers of attorney, and that kind of thing. We also do interdictions, which are when you have to have someone declared legally incompetent as an adult to take care of them. And then we also have we do the succession side, which is many people refer to it as the probate. And we'll go into that so I can explain it a little bit more. The other picture where it says Lanyap Fiduciary Services, that is another company that I run, and I started it in 2016. The reason I started it was I was having trouble getting people, getting companies to handle what they consider a small trust, and so most of these large trust companies were requiring people to have million plus, sometimes more than that, before they would even talk to them about managing a trust for a disabled person. And why would you need a trust for a disabled person? I'm going to get to that. But that's really what we do. That's all we do. So, you won't see us doing, much in any other realm. And I've been basically focusing on this for about the past 25 to 30 years. The first few years of my practice, I didn't know any lawyers, so I just hung out my shingle and I was just doing everything, which was good, good experience. And I got to, know a little bit about a lot of things. But as time passed, I focus on this area. So, Chanel, if you could go forward about 4 slides, um, that would be great. So this is just general information about me. We do have an office. We have an office in Benton as well as Shreveport. We are actually going to be moving to a new office in Shreveport. It'll be open on October 8th. So it will be on at 7735 East Kings Highway. That is out. If many of you know, I used to call that area Harts Island Road. So it's actually past Captain Shreve going south toward LSU. It's right next to Bergeron's if you've ever gone out there and gotten anything to eat at Bergeron's. But it's going to be great. It's going to be very spacious, lots of parking places, easy to find. So, and we'll be having some sort of event there, hopefully around the first of the year. And any of you, of course, would be welcome to come. So a couple, maybe go forward, Chanel, to the lanyap side. Okay, yeah, I've already talked about that. This is the people who currently work with me. And we're about to add some more people as we move. But what has happened is been very, very fortunate to have a lot of great people working with me. As I mentioned, my daughter works with me. Connor, who's the lone male there in the middle, is also a lawyer. And we have several paralegals and assistants and marketing people. And our bookkeeper's not on that picture, but we'll have to get there. So, okay, so let's go to the next slide. That's what I was talking about where we manage things for people. So, sometimes people who have someone who has special needs and they need to set up a trust that would benefit them or take care of them after their parent or whoever's taking care of them passes away. Sometimes they need someone to coordinate benefits, to make sure that they're getting the appropriate housing, and just kind of do everything that you parents or caregivers are doing now. And if you were to pass away, this is a role, and you didn't have anyone in your family that could step into the role. This is a role that we do. Okay, so let's go to the next one because this is really what you guys are interested in. That's again about the company. Let's go to the next slide. Okay, so the main thing that I hope everyone will take away from today is that you really need to do some sort of estate planning. And so what happens is people tell me all the time, I don't have an estate. Well, if you own anything, you have an estate. Okay. So, and when you have a disabled person that you are taking care of, you have to make sure that you make plans so that if you pass away and they become your heir, what they receive from you does not jeopardize their assistance that they may be receiving through Medicaid or through other government agencies. So the starting point for all estate planning is the fact that Louisiana is a community property state. So Louisiana does not care if your name is not on the title to the car, if you bought the car with your husband or with your wife during a marriage, or with your partner. It is considered community property. And so at the time of death, everything that's been acquired during the marriage is owned by the one spouse, is owned by the two spouses 50%. Okay. So the only alternative to that is separate property if that's something that you inherited from your parents or you were given separately. So that's always our starting point is, do you have community property, which most people do? And then do you have separate property, and how are we going to deal with those things? So what people think, I found, is that most people believe that if your spouse dies, the surviving spouse receives everything. And that is not true. So in order for your spouse to inherit from you, you have to make a will. And if you don't make a will, the children inherit and the spouse just has the right of use over community property. And so it gets a little confusing because people don't understand that. And they're like, well, that doesn't make sense. Well, it may not make sense, but that's what the law is. So the most important thing is to start with a will. It can be a simple will. It can be a few paragraphs, but Louisiana has very specific rules about wills. So if you go on the internet and you print something off or you fill in the blank, it's likely not going to be valid. Wills are not expensive. And we have different tiers of estate planning for what people may need. And we do have people who say, hey, I just can't afford it right now. But what I want to do is I want to pay a little bit each month until I get this done. We're happy to do that. We really feel really strongly about you getting this done. It's very sad when someone calls from the hospital and says, you know, so and so is dying and they don't have a will, and what do I do? It's too late. There's nothing we can do at that point, right? Or the person has become incapable and they can't make any decisions anymore. There's nothing I can do. So if everyone would just take the time to just kind of find out what would happen with their assets when they pass away, and then take some action to make sure their special needs person is protected, it would it would be so wonderful. It would just be great. The statistics are that less than 30% of people over the age of 55 have any sort of estate planning. So it's, it's on and on and on every single day where I have to tell someone, I'm sorry, but you don't own that. And that's it's hard. So okay, so that's descent and distribution. Now the next thing that's very, very important is the next slide. So forced heirship. Forced heirship says if you have a child who is under age 24 or who has a permanent disability of any kind, they are a forced heir. And what does that mean? That means that you must leave them a share of your assets when you pass away. If you do not, the state will require you to do so. And so if you have, for instance, a house and you die and you have a special needs child and you haven't done a will or anything to protect that child, they're going to be a forced heir. They're going to inherit a share of that house, and it's going to be probably worth more than $2,000. And we know what happens at that point. So at that point, that ownership transfer is reported to Medicaid and the person is removed from the program. So you've got to be very, very vigilant about doing something if you have a special needs person who is your child. Then people say, oh, no, we don't have that anymore. We got rid of that a long time ago. We did not get rid of it entirely. Louisiana still has it for children under age 24 and special needs persons. So if you have a child who is special needs, or someone under age 24, you must make a provision for them in a will, okay? If you don't, it'll be forced on you, and if they are on benefits, it will very likely affect it. So, if you are listening to this and you haven't done anything to protect your special needs child, we need to do that very, very soon. So you need to put that on your to-do list at the very top, okay? Um, so, let's go to the next slide. So I talked a little bit about the difference between separate and community property. And so what happens is if you have one special needs child, that child must receive an undivided quarter of your estate. So that means if you're married and the child is your joint child, that means that child gets a quarter of each parent's estate. Okay. And even you can see now, even in a small estate, $2,000 is going to, likely they're going to inherit more than $2,000. Okay. So you really need to handle that. And this is same percentage for separate property as well. Okay. Then we have this other, let's go to the next slide. Then we have this other, interesting thing in Louisiana, and that says if your child died, so let's say that I had a child who died, and that child had a child, my grandchild, and my grandchild was special needs, and I don't have a will, and I die, that special needs child comes up to inherit from my estate by representation. So they end up stepping in the shoes of their deceased parent. And this is confusing to a lot of people. They think that they don't have to make a plan because they're a grandparent, and the child is the special needs person is a grandchild. Again, if you don't have a will that says what happens, this representation happens and can still jeopardize benefits. Okay, so okay, so let's go to the next slide. So So what can you do? What can you do if you want to protect your special needs child or grandchild, or you're taking care of someone who's not your child or grandchild, and you want to make sure if you pass away that there's their funds or their assets that are going to be set aside for them. Okay. So the only thing that is protected is a special needs trust. A special needs trust, there are two main kinds, but a special needs trust, a disabled person may be a beneficiary of a special needs trust, and the trust can be set up for their benefit, and that can is an allowable trust that does not affect their benefits. Okay, so if you, like I said, if you've got a special needs person, if you don't have a special needs trust, it's very likely their government benefits will be affected if you pass away. Okay. So you need a will and a companion special needs trust that says whatever this child is going to receive from me, either by what I want to leave them or either by forced heirship, is going to go in a special needs trust for their benefit. Okay. Um, so this is the only thing that's available. There's not any other options. And so you just have to do it. I mean, there just isn't anything else. Um, so okay, the question is just do you want me to do the question, Chanel?
Yes, that's fine.
Okay, so it's the question was, does this affect kids on Medicaid through the TEFRA program? Is that what you're asking me?
Yes, that's correct.
Okay, it affects anybody, any child of any kind. I mean, on any benefit. Okay, so if it's a means tested benefit, if it's a benefit that they receive that has an income limit, which most of them do, income or asset limit, then it will affect them. And I don't know the ins and outs of that particular program, so but I'm happy to find out about that. But in general, okay, so she says TEFRA doesn't go by income disability. So um,
I'm
if
gonna
it doesn't
chime
go by
in.
income or assets, then it may not affect them. But wouldn't that person also be on other benefits that are income tested? That's what I would want to know, maybe. So I can find out about that. Okay. So the other thing is that if someone inherits and they inherit more than the Medicaid limit, there may be a period of ineligibility. And then, so the person would lose benefits for a period of time until those assets were spent down to the allowable limit. And then they'd have to reapply and get back on the program. So, again, I just think you don't want to mess around with it. I think if you have a special needs person, you need to do it. Okay. Medicaid also has the right to lien property that is inherited by a person who has received benefits. And so they are allowed to send a letter that says, hey, this person received benefits and we understand that they have received an inheritance. We need you to send this information in. And we now have a lien or a right to seize the asset and pay Medicaid back. Okay. So it becomes very complicated and scary. But again, if you have the correct kind of special needs trust, um, it should work great. And you can send the special needs trust in and say, hey, I have this. This is where it went. And we know by federal law that this trust is acceptable and not subject to Medicaid payback. Okay. All right. So the next slide is just, do you see how important it is to have a will? Okay, I'm going to spend a little bit more time on special needs trust in a few minutes, but I wanted to just back up a step about the will. I did say it's very important to have the will. The will, it again, should not be something printed off the internet. You don't have to go to a lawyer, but we do see a lot of bad wills. We do see a lot of wills that don't meet the Louisiana requirements. I see wills where people try to eliminate their special needs child, or not give them the full percentage they're required to get under law. That would invalidate it. So I see people say, well, I'm only going to leave them 5%, or I'm going to leave them out entirely. You just can't do it like that. So you just want to make sure that it's valid. We review wills all the time. There'll be my email is going to be in this program, and you're welcome to send something if you want to scan it in and let us take a look, and I can say it's good or bad, or you can drop it off or anything like that if you want us to take a look. We are very fortunate. We have a great business. And so because somebody said, well, why, you're just trying to make business. Why wouldn't you just say all the wills are invalid? I'm so fortunate that I don't have to do something like that. That would be, not only unethical, but just morally, we would never do that, number one. But also, um, we have a huge business. We took in over 800 new clients last year. I'm working 12 hours a day, sometimes 6 days a week, usually on one day I try to take a half day. But we're very, very busy. We're very fortunate. I can look at it and I can tell you in about 2 minutes if it's going to work. Okay. So it's no big deal for us to take a look. And if you've got one and it's valid, wonderful. Okay. All right, let's go to the next slide. Okay, I think you can go one more. Okay, so this is a little hard to read. I touched on this before. So the importance of a special needs trust. Okay, so how does it work? So a trust is basically a document. When you create it, it's just a document, right? And so we create it, meaning that we draw it up, and it's paperwork, right? So if you have a special needs person and we're doing a trust for you, we create it, but you don't put anything in it now, okay? You can, but most people don't. So at the time of your death, what that forced heirship portion goes into the trust for the benefit of the disabled person, and then it's a protected asset from Medicaid or other benefits. That kind of trust is what we call a third party trust. That means that the child or the disabled person never took possession of the asset. All right. So that means that we had somebody who was proactive. They made their will, they made their special needs trust, and everything was set up before they died. And so when that special needs person is recognized as a forced heir, it just went from the deceased person to the trust and never was actually owned by the special needs person. Okay, that's the way you have to do it to protect it. All right. So what happens, unfortunately, and let me back up a step. So there's a trustee who's a person who's in charge of the funds, the asset or the funds, right? And that person can be a parent. It can be, a friend. It can be somebody who's been taking care of that person. But you want to think about it when you're choosing a trustee, because you want to make sure that it's someone who is likely going to outlive your special needs child or person. So we don't want to put somebody that's, 90 years old and you have a special needs person who's 40. Okay. The likelihood is that older person would not be around. You also want to make sure that the person you choose as trustee understands the rules of a special needs trust. So a special needs trust, there are things that a special needs trust can pay for and things they cannot pay for. So if you have somebody who doesn't understand the rules and starts paying for things that the disabled person is not approved to have through Medicaid, you will jeopardize the entire trust. So you got to be really careful about that. And then the third thing is you need to think, well, two more things. You need to think about the security of who you're choosing as trustee. And by that, I mean, a person who's a trustee of a trust has the ability to withdraw funds. Okay. They have the ability to sell property, withdraw funds, do a lot of things. And if you don't have someone in that role who is bonded or who has some kind of insurance to protect in the event that trustee misuses the funds, you could very likely end up in a situation where the special needs person's trust funds have been misused and they're left with nothing. And we unfortunately see that sometimes. It's very sad. And usually it's someone who is a family member and I guess the temptation gets to them and they spend the money. And so it's terrible. But you want to make sure that you've got someone in that position that understands the role. The other thing to think about when you're choosing a trustee is that depending on the level of function of your special needs person, sometimes there is a conflict between the trustee and the special needs person, meaning that the special needs person believes that they are entitled to receive more than they should be getting from their trust. And in a family situation, sometimes that causes problems because the uncle or the aunt or the sister or the brother has to be the one to tell them no, and sometimes it doesn't go well. So we just want to think about those kind of things. Okay. Um, let's go to the next slide. Okay, so we talked about this a second. So the parent or the guardian can choose the person to administer the trust. That's called the trustee. It allows support for the disabled person, but doesn't cause a loss of benefits. You must follow the specific rules. And there are specific rules that are found in the Social Security Administration handbook, and they are huge and would take us years to read all of them. But they're summarized, and people who do this all the time understand them. Okay. So you're not supposed to be making cash distributions. You're also not supposed to pay for shelter, which is housing, and you're also not supposed to pay for food. There are some exceptions to those things, and I know that seems everybody says that seems so weird, right? Why can't you pay for housing? The reason you're not supposed to pay for housing is that there are approved facilities allowed that housing is allowed. There seems to be a little easing up of this particular rule, and hopefully it'll continue to ease because that is a major area of contention in handling the trust. Okay, let's go to the next slide. Okay, so remember when I talked to you about making sure this is all set up before you pass away, and so that the the asset never becomes the property of the disabled person. So let's say that someone dies and they haven't done anything. Okay, they haven't done we see this all the time. Haven't done anything. They come in and they have a disabled child. And I say, okay, well, the disabled child is a forced heir and they are now going to receive more than $2,000. It's going to affect their benefits. And so whoever's in charge of handling the estate will say, what can we do? Okay. So we already talked about the one that's set up that you plan ahead of time. That one does not require any Medicaid payback. So if I set up a trust for the benefit of a special needs child and I die and the asset goes from my estate to that trust, there is no reimbursement from those trust funds to Medicaid when that child dies. Okay. It can pass on to other family members or, facility, charity, whoever, right? Now, let's say I don't do anything. Then I'm stuck, right? So I'm like, what? Well, what are we going to do now? Because this special needs person is going to be inheriting. In that case, you can still use what's called a first party special needs trust. However, it still works the same way, except that when the special needs person dies, Medicaid has to be notified, and they have to be offered whatever is left in the trust. So if that person has not, if it hasn't been spent by the time the special needs person dies, it goes back to the state that administered Medicaid, okay, or any other benefit. There's a whole set of rules that have to be followed to offer the funds back. We do also see these first party special needs trust used commonly when you have someone who is injured, who has become disabled as a result of an accident. And so in that case, let's say it's there's a medical malpractice case, an automobile accident. So we do set these up, and these are available because at that point, it is the disabled person's funds, and we have to get a judge to approve the funds to go into this trust. But again, a first party special needs trust the funds have to go back to Medicaid or the government, whatever assistance that they was received. Okay. Um, okay, let's go to the next slide. Okay. So I just said this first party trust is created with the disabled beneficiary's own funds and is subject to government payback. A third party special needs trust is created with funds from a third party. A third party would be like a parent, an aunt, an uncle, a relative, whatever, whoever wants to leave something to them. So it's extremely important to make sure that whoever is drafting the trust understands which kind of trust needs to be used. If it's and I have seen this happen. I've seen people I've seen estate planning documents where someone has tried to do a third party trust and has inadvertently done a first, which means that the money goes back. So you want to make sure again that you got somebody who knows how to do it. All right. Okay, let's go to the next one. So what can the special needs trust pay for? So in general, there's a whole laundry list, as I said, but in general, the special needs trust can pay for medical and dental expenses that are not otherwise covered, transportation expenses, whether that's by bus, it's paying someone to take them somewhere, anything like that, any transportation expenses, any rehabilitation or therapy services, again, that aren't already covered, so extra things. Household supplies, cleaning supplies, paper products, all those kind of things can be paid for. This is one that people don't normally know. A special needs trust can pay for entertainment and vacation expenses of a disabled person, including the expenses of a paid companion. So we have people in some of the trusts we manage who would like to go on a trip, and they can go. The trust pays for them and also pays for one person to accompany them. Entertainment expenses, educational expenses, including things that like special computers, special wheelchairs, things like that, maybe an upgrade from what they already have, special kind of beds, additional therapies, all those kind of things. Subscriptions. So, any kind of subscription, including cell phone bills. So people are like, wait, you can pay for a cell phone, but you can't pay for a house. That's true. So yeah. So again, you can see how why you would why you would need someone who knows what they're doing to handle the trust. Okay, let's see. I thought I saw something here. Yes, again, you're right. It does pay for vacations, but not housing. So usually what we do when on the trust that we manage, and we go over this list with people, is say, okay, we can't pay rent and utilities, but if we say, okay, we can't pay rent and utilities from this trust, but we can pay all these other things, then if we can pay all these other things, maybe what you're getting in a disability payment can pay for the housing. So you have to kind of budget for it. Okay. Okay. You want to go to the next slide? Okay. So I don't know that this is, that interesting to y'all. There are some tax consequences of the different types of special needs trust. In that first party trust, if like let's say that there's a fair amount of money in it, and it's generating a lot of income, it's going to flow back out to the individual, and so that can again be a source that becomes more than the limit. Okay, let's see. The question is, if a third-party trust is established, can more than one family member utilize it if a special needs trust is left in their will, or will each family member need to establish their own trust for the same child? Everyone can use the same trust, which is so great, right? Because then if mom and dad want to set one up or grandparents want to set one up, as long as it's done correctly the first time, everybody can reference it in their will. So, yeah, everyone can use the same one. You really only need one. So if it's if you're a couple and it's your child, we don't have to do one for each of you. We don't have to do another one for your parents or another one for your aunt or anybody. We're just the same one all across the board. Okay, let's go to the next slide. Okay, I talked about this a little bit. The benefits of using a corporate or business person as a trustee as opposed to a family member. And I already kind of went over this, but you do want to again, make sure that it's someone who understands the role. There are lots of trust of family members who are trustees of special needs trust who are doing a good job. I'm not trying to say that everyone as a family member is not doing a good job. There are a lot of people who are doing an excellent job, but I do think it gets harder as that trustee ages and maybe isn't able to continue in the role. A lot of times, someone may have, like you may say, okay, my spouse and myself want to be the initial trustees. That's great, but maybe we need to figure out who we can put in the next role. Okay. There are there are a lot of people who not a lot of people, but there are quite a few companies that do it. And you want to, when you're choosing the trustee, you also want to talk about fees, okay? Because all trustees are going to charge a fee. You want to find out what the fee is. Some of the large trust companies are around 6% a year, and that's whatever's in the trust that's being taxed. And a lot of them have minimums where you have to pay a certain amount a year and so things like that. So whoever you're considering, you need to think about that. Okay. We can go to the next one. Okay. Are there any other questions about special needs trust before I go into interdiction, which is where a person is declared legally incompetent? I don't want to jump out of that. If anybody have any more questions about that. Okay. If you think of something later, just post it. I'll swing back around to it. Okay. All right. So another big issue for you is what happens when the special needs person is over 18 and is not capable of making their own decisions. If they're not capable and they're over 18, they cannot make a power of attorney. So, a power of attorney the person who gives someone else power of attorney has to know and understand the consequences of what they're doing. So if it's a person who's special needs and they are not capable of making those kind of decisions, the only other alternative is to go through the interdiction process. The interdiction process in Louisiana is, in my opinion, very cumbersome and expensive. There has to be a lawyer appointed to represent the special needs person, interview them, talk to the family, and there has to be a doctor who is willing to testify that the person is not capable of making their decisions. So the standard is not consistently capable of making their decisions, financial or healthcare, or both. And so that kind of gets us sometimes into a little bit of a fuzzy area. You may have people who are actually fairly functional physically, but mentally cannot make a complicated decision or a financial decision. Or you could have the opposite. You could have someone who who can make the decision, but has physical limitations that prevent them from acting. Okay. So now if it's a person who was born with a disability or who got a disability as a minor, as a child or a person under 18, your only really alternative is to go through this process once they reach 18. So there's a petition. The court will appoint a curator, which it's called guardian in a lot of places. It's the same role. So that person can be a family member or a professional person, and you can have different people that are appointed to make the healthcare decisions or the financial decisions. You may have someone who's good with paying the bills, and you want them for that, but you want someone else to actually be the making the healthcare issues. So, or you can have the same one. There's steps that are, like I said, complicated. They have to actually be served by the sheriff. A lawyer is appointed. There's a hearing, and then the judge will issue an order and appoint a guardian. The guardian or the curator cannot have a felony, and if they have a felony, they are not eligible to act in that role. They also cannot owe the special needs person, any money. And this tricks people up a little bit, because sometimes we do have people who maybe have used some of the special needs person's assets for their own personal benefit. And if that happens, they become disqualified from this role. It's always preferable, to have someone in this role who has, in my opinion, direct contact with the special needs person, or is willing to have direct contact. I think you want someone, especially for the ongoing care. Financial, they could do financial from a long way away, but for the ongoing care of the person, even if they're in a facility, I think you need to have someone who is willing and able to check in and to see how the person's doing and what they need. If it's not daily, it doesn't have to be daily, but fairly frequently, at least monthly, and just kind of making sure that everything is moving along and that they're being taken care of well. Okay. Okay, let's go to the next one. Okay, you don't have to read this. This is a whole, so if you came to our office and we were going to do an interdiction or have somebody declared legally incompetent, that's what interdiction is, you would be given this sheet and we would go over it. The reason that we do this is because it's hard to remember all these little details. And, so we tell you what I just said, and then we give you the sheet that goes over it again. Okay. Let's go to the next slide. So the curator or the guardian is going to be the person who's making the healthcare and the financial decisions. And that person is also going to make a decision as to where the person lives, whether that's living at home with assistance, whether that's in a facility, where that facility is located, all those kind of things. Those are decisions that they would be making. If the disabled person, the special needs person, owned property, that guardian would have the ability to request the property be sold or it invested. That person also has the ability to direct assets to a special needs trust. So, and that happens quite a bit. So it's a big job. It's an important job. And they have a lot of power. Okay. All right. The next slide, again, is something that we would give you if you came into our office. It just says, what's a will? What does a will do? What's a living will? A living will it's very confusing because it's not a will and it's about terminating life support is what it's about. Louisiana only has one format for that document, and that's something that we try to encourage everybody to do as part of their planning. The other thing is a power of attorney is very important. If you are capable of making a power of attorney, it's very, very important to have one, because if you become disabled, if you get in a car accident, you develop some disease to where you cannot take care of your assets or make your own healthcare decisions, we want you to be someone to be able to act for you with the power of attorney. So we just talked about the interdiction process, where what happens if someone's has to go to court to be appointed as someone's guardian. So, the contrast between just doing a power of attorney, which is a document that we do in our office, that cost, as opposed to having to have that huge, ordeal of all these things and a court-appointed lawyer and a doctor to testify and a hearing. You can see how much more expensive an interdiction would be. If you have a power of attorney and you become disabled, then your agent and that power of attorney can just start acting. There's no court authority required. Okay, the other things on here, the last part of it has to do with forced heirship, which I've already talked about. And the center part has to do with a trust for a child. That kind of trust for a child or grandchild or whoever is set up for to allow distributions at certain ages. And this doesn't really apply to special needs in the special needs area. It does apply if you have children or grandchildren or other minors or people who are maybe just not good with money, that you want to have them not receive everything all at once. Okay, let's go to the next slide. Okay, I think that everybody has probably heard or knows someone who's been in a situation like this picture. Okay, and usually this kind of thing, a argument, bad feelings, hurt feelings come about because someone has died without any planning. Okay. And it's very stressful on the family. It's very stressful on everybody. But you can avoid this kind of situation just by doing some simple planning. And I would just greatly encourage you to do it. Let's go to the next slide. Okay, we try to encourage everyone to have these documents. Everyone needs a will. Everyone needs a power of attorney that covers financial and health care. Everybody needs a living will to decide what happens in the event that you need to be taken off life support. And you may need a trust. Not everybody needs a trust, but a person with a special needs child does need a special needs trust. And then once you do them, we try to get everybody to kind of say, and I'm going to tell you, I'm guilty of this. Look at it every so often. If you have something major happen in your life, you get remarried, you move, whatever, you need to periodically take these things out and take a look at them and see if they say what you want them to say. I can tell you that I am remiss about it, and this is something I do every day. I found out that when I went on I was going, you know how you do when you get ready to go out of town, getting ready to go out of town, I thought, I need to go pull that stuff out and lay it on my desk in case something happens, and then everybody will know what to do. And I pulled it out, and I was shocked at what I had put about who was at that time. I had my son was still a minor, who was going to take care of my child. I was like, wait, why did I put that person? And I had completely forgotten about it. And luckily he's 26 years old now, so we never had to, worry about that. But I'm just saying that, it's not this taking care of these things is not the most fun thing to do. It's not probably where you want to spend your money. You'd probably rather be going on a trip. You'd rather be doing something fun. But it's very important. And I will tell you that most people who come here and we talk to, they tell me they feel so much better knowing that they have it done. Okay. Okay, let's go to the next one. I talked about the power of attorney already. And we touched on that. It's just important to have it. The alternative is the interdiction, expensive interdiction process. And then the next one, the living will. The living will is just where you don't want to be kept alive on life support, and you're designating someone to make your decisions for you if you can't speak or you're in a coma. Okay. A very simple document. It is, there's only one format. Louisiana has one format. And so you just want to make sure what you have is Louisiana's format. Okay, let's go to the next slide. Okay, why would you need a trust? We talked about this in the beginning. If you have a special needs child, because that child's a forced heir. If you want to take property out of your estate, and that's a whole nother issue that has to do with people who potentially have federal estate tax issues. If you want to give money or assets with restrictions, like you want children or grandchildren to receive from you, but you think they're immature or you want them to wait until they're older. Or you want them to wait till they're out of college or they have a job or whatever, okay? We also have people who want to set up a trust to protect their assets to stay within their own families. And you can do a trust, you can create a trust now that you work with now, or you can have one that becomes effective upon your death. A trust is a separate legal entity. It is not, so if you put something in a trust, it is no longer owned by you. Okay. Um, with the exception of what I'm getting ready to say. So let's go to the next slide. Okay. I hope what you've gotten out of today is you understand that Louisiana has very specific rules about things, right? And also that it's very important to have the correct type of trust for a disabled person. We do have people a lot of times who will try to set up these living trusts. A living trust is really not needed in Louisiana. We have no inheritance tax in the state of Louisiana. So you really don't need to do a living trust to, quote, avoid probate. If you look at the information that's being put out about getting a living trust or putting all your property in a living trust, you're going to see that that is not specifically geared to Louisiana residents. We spend a lot of time undoing these things because they're done inappropriately, and they're not. Anytime someone wants to sell you something that is a one size fits all. So if you go to one of these seminars at one of the restaurants, I always tell people, I'm like, go get the free meal. I mean, go get the free meal, get the information. This doesn't hurt anything. Just don't sign anything, because those things are sold mostly by salespeople. And they're not trying to gear something towards your particular situation. So anytime someone says, I'm going to create this for you and I'm just going to fill in the blanks and, change your name with your neighbor who got the same thing, that's not listening to you and what you and your family need. So you want to make sure that whoever you're dealing with is talking about your specific needs. Okay. All right, let's go to the next slide. Do you participants out there, I'm just going to talk a little bit about what happens when somebody dies, but I'm happy to go back over any of the things that may be more interesting to you in terms of like the trust or the interdiction process. We've got, about 10 more minutes, I guess. So this is just kind of the steps that we follow when someone passes away. So hopefully the person who passed away has a will. And if they do, we're going to want to present that will to the judge and have the will formally declared valid. And there's an executor appointed, and that executor then will be able to start working. Okay. So if you don't have a will, there's no executor. And if you don't have a will and there's no executor and there's things that need to be handled, then we have to appoint an administrator of the estate. And depending on what the family dynamics and relationship of the heirs are, that can be fairly stressful, because if you don't have the agreement of all the heirs, you have to go through a process to be approved, and you have to go through a process to post a bond, which is like an insurance policy that you would do a good job. It's just so much easier to have a valid will and have an executor in place. So the second step is that we close the estate and the heirs become the owners of the property. Okay, let's go to the next one. Okay, so this is basically what I just said. And there's, the probate process is basically step one of the succession. So succession means the transfer of assets from a deceased person to their heirs, or to legatees, which are people who are named in the will. People use the term probate to mean the whole process, and that's okay. But probate really just means the will's declared valid. Okay. There are requirements for a probate to be filed. There's specific rules, and Louisiana has specific rules, just like every other state has specific rules as to what's appropriate and what's allowable. If the documents are not done correctly on the probate request, the judge will reject it. As I said, we do, I've done I don't know how many thousands and thousands and thousands of them. There are, of course, similarities to them, but uh, all of them are different. All of them have some difference because we're all individuals and we have different people involved in different issues. Okay, so let's go to the next one.
There is a question in the chat.
Oh, okay. Let me see.
Oh, I'm sorry. He just put it to us. So it
Oh, I
says,
see it. Is this one if a person is interdicted as a minor?
yes.
Okay. So interdiction, the person has to be 18 for the interdiction. Okay. What people sometimes file before 18 is a continuing tutorship. I don't really like continuing tutorship because there's some restrictions on that. Um, and I would prefer to wait until the child is 18. When the child is under 18, the parents already, by operation of law, have the right to act on their behalf. So I don't really think the continuing tutorship is necessary while they're a minor. That's usually done between 15 and 18. I would rather wait until 18 and file for the interdiction. And then once the interdiction is done, it is forever. The only way to undo an interdiction is for the person who has been declared incompetent. That person would have to make a request through the court and show the judge that they are no longer incapable. So very, very few interdictions are ever overturned. Um, the only time I've ever really seen that happen is where you have someone who's maybe in an accident and they have a period of time in which they are not able to do anything, but then they recover enough to where they can regain some of their rights to manage their own things again. It's very unusual that someone is, in a special needs situation. Usually there's not much movement in terms of their abilities. Actually I'll say normally it's a decline. So I would prefer to wait until the person's 18 and not do the thing between 15 and 18. I think it's kind of a duplication of effort. We do have a lot of people who will say, hey, my child's going to be 18 on, December 1st. Can I get started? And I'm like, yeah, because it takes us about 3 weeks to get paperwork ready anyway. And we got to coordinate with a doctor's statement and all this. So the sooner you come in and say, hey, my child's going to be 18 on this date, we can plan it so we file it on their 18th birthday. And then it's seamless from that point forward. Okay. This just has to do with administering an estate when you have things like debts and how, things to sell and things like that. Most of the time, we're not doing what we call a full administration. We're just doing some kind of limited procedure because most of the time, the people who are inheriting is either going to be the spouse or children, and they most of the time have an idea as to what they want to do, or maybe they want to just receive the property and then decide what to do with it, as they get it in joint ownership. Okay, let's go to the next one. So when someone passes away, we have to list everything that they own or had an interest in and also all their debts. Again, so now remember what I said, how we determine what a person owns. We have to apply the community property rules that apply in Louisiana. Unless you have a separate property agreement, otherwise known as a prenup, we're going to list everything. Okay, so we're going to list everything that it was owned jointly or in any individual name while the person was alive. There are some differences. So, and I should have said this in the beginning. Okay, so there are some things that are not subject to forced heirship. What is not subject to forced heirship? Life insurance. Okay, if you have a life insurance policy and you have named someone and your special needs person is not named, that life insurance policy goes to whoever you have named. There is no forced heirship on life insurance. There is no forced heirship on a retirement account. of any kind, whether it's a 401k, a 401(k), an IRA, a Roth IRA, all of those have named beneficiaries. So forced heirship does not apply to those. If you have property that you are a beneficiary of a trust and the special needs person is not a beneficiary, then that would also not be included. Okay. Um, so whenever we meet with someone about an estate plan, we go through this, like, what are your assets? Do you have designated beneficiaries? Sometimes we see people who put a special needs person as a beneficiary of a life insurance policy or a retirement account, and that is a very bad idea, okay? Because what happens, they inherit that, and it's usually more than $2,000, and that's gonna affect our special needs person's benefit, okay? Let's go to the next one. Okay, Louisiana has no inheritance tax. I told you all that before. And federal estate tax starts at $11 million. So that means a person's estate in Louisiana would have to be very, very large before there would be any taxes owed upon a death. So Louisiana is favorable in that situation because your heirs are able to inherit the property tax-free in Louisiana. Let's go to the next one. Oh, that's the end. Okay. I forgot that was the last slide. Goodness. I did this about 6 months ago. Okay. So, any other questions? On this last page is, our website, which is miramonlaw.com. There's a lot of information on that website. There are a lot of articles and blogs on there. You can also send a question through the website if you want to do that. My direct email is that little green one in the far right. If you want to send me an email directly, that will come directly to me and not go through the web page. Or you could go through the web page and make a request there. And we would love to hear from you. We'd love to help you. We do just I should have touched on this for a second. Most of what we do is flat rate fee. So if you came to our office, you would likely have an initial consultation that was free. At the end of that initial consultation, if we thought we could help you, we would give you a price and a fee agreement. You would pay half down. You would pay the balance when you came back to sign the documents. It usually takes about 2 weeks to get an appointment with one of us. It usually takes about 3 weeks for us to have the documents prepared. And like I said, most of the time it's a flat rate. We do this so many times, we know exactly, after talking to you for probably 15 minutes, I can tell you, what I think you need and how much it's going to cost. So that's the way we work. When you call for an appointment, we have several intake ladies, and they will ask you a few questions. The main thing is your name and what are you calling about. We want to make sure we don't have any kind of conflict with any prior representation of anyone. So we will have to have your name and anybody else's name that's involved. And they will direct you to either where to go on the website for the correct forms to fill out before our appointment. Or if you don't want to go through the website and you're like, I don't want to do that, just mail them to me or whatever, we'll send them to you in whatever format you want. So that when you have your appointment and you come in, we don't spend time saying, what's your name, what's your address, right? We're able to get to the heart of what you're there for pretty quick, and it saves time. We do have, we are able to stay late on certain days if you are, don't want to have to miss work. We are also open the second Saturday of every month from 9 to 1, which has been very popular because a lot of, it's just hard to, take off work and get somewhere. You can also request a telephone conference or a Zoom if you don't want to make it to the office, and we're happy to do that as well. That's all.
All right. Well, thank you, Patricia, so much. If you have a question, we have a pretty small group. So if you have a question and you didn't get a chance to put it in the chat, you can raise your hand and I will unmute you and let you ask your question directly to Miss Patricia. I want to thank you so much for your time today. And for everyone, this webinar was recorded, so it will be uploaded to our YouTube channel later today. So you will get an email with the YouTube link in it so that you can go back and reference it for any information that you need. I don't see any hands raised, but I do see in the chat, very informative. Thank you. So yeah, just thank you. So for our upcoming events, please go to our website at www.fhfregion, and that's the number 7.com. Click on upcoming events and you will see a list of our upcoming workshops. We have some more that are coming up for you, and everyone is just saying thank you. Very good information. So again, we want to thank you guys for spending this morning with us. We're going to let you go so you can go and enjoy your lunch, and we hope to see you on the next one.
Thank you.
Thank you. Bye-bye, everyone.
Bye-bye.